Hello there, my name is Toby Wilbraham and I'm a solicitor advocate based at Olliers Solicitors in Manchester, advising all aspects of criminal law. And what we're here to talk about today is when somebody wishes to appeal a conviction from the Crown Court to the Court of Appeal. Please note that this information is not meant to be exhaustive, and if you have any queries, please feel free to contact myself or the appeals team at Olliers, either by telephone or by email. So the first thing to know is that appealing a conviction is not automatic. You need to get leave to appeal before the Court of Appeal will hear the case. And the purpose of this is to exclude cases where there is no real merit to them from the ones where there is merit to them. So the time limit for making an application from conviction at the Crown Court is 28 days. So the application needs to go in that time period, and there'll be an official court form. And with that form, you need to enclose grounds of appeal and advice on appeal with that. That's usually drafted by a barrister, but can be drafted by a solicitor. Can also be filled in by a defendant, but I would advise against this. I would really advise you get advice before you proceed with due to the fact that you could receive additional time if the court feel there is no merit to the application. So the sole grounds to appealing a conviction is if the conviction is unsafe, and I'll talk about this in a bit more detail in a separate video, because it could be due to a number of different reasons. The procedure for appealing the conviction is that the application goes before a single judge first. This is a male or a female judge that just looks at the application, looks at the prosecution facts, looks at the submissions made, looks at the general overview of the case, and decides whether they feel there is leave for us to go further to a full Court of Appeal. The single judge will either grant leave, which is good news, at which case the case proceeds to a full panel of judges at the Court of Appeal. The judge could decide there's no leave to appeal that, and that's the difficult stage to make a decision, because there's two choices that can then be made: either to proceed to the full panel of judges or to abandon the appeal at that stage. Most of the time people abandon the appeal at that stage because the judge at that stage has indicated that they don't feel there's leave, so the likelihood is that the Court of Appeal probably will feel the same, though that's not definite. The problem is, if the appeal is proceeded with at that stage, there is a risk that if the Court of Appeal feel there is no merit to the appeal, then they could add additional time to a sentence. This is the time period from which the person has applied for leave to appeal to the date the hearing is heard. All that time can be disregarded from the person's sentence, so in effect they served a longer sentence than they would otherwise have served. So you really must make sure you take advice in relation to this before an appeal is made, because there is that risk. So if the appeal is successful, the court will quash the conviction and it is removed from the official record. In some circumstances, the court may set aside the conviction but allow the prosecution to start a new trial against you. If the appeal is unsuccessful, normally no change is made to the trial verdict, but in some cases the appeal court may substitute a conviction for a less serious crime, though this cannot normally be done on appeal from the magistrate's court. So in conclusion, I would strongly advise you get good advice in relation to whether you should lodge an appeal in the first place or pursue an appeal because of the potential implications for doing so.